in their criminal code, as Missouri does. The ABA developed these recommendations through extensive work of an ABA committee consisting of judges, prosecutor, defense counsel, and members of the academic community. The task of our assessment team was was to conduct an exhaustive review of the laws and the procedures and the practices by which the death penalty is implemented in Missouri, and then determine if our state is in compliance with each of these 93 ABA recommendations. We agreed as a team that we would use those ABA recommendations as the framework for our assessment of the death penalty in Missouri. Our role was not to determine whether Missouri should or should not have a death penalty, or whether Missouri should or should not have a moratorium on the imposition of the death penalty. Those issues were not even addressed or discussed with our group. Team members were not required to support or oppose the death penalty, and although we didn't discuss it from our various conversations, I would say that team members have a diverse opinion on the issues of the death penalty. What I can say is that all of the team members are committed to having the application of the death penalty in Missouri to be fair and accurate. So our mission was to research the death penalty in Missouri to determine the extent to which the Missouri system guarantees fairness in administration of the death penalty and minimizes the risk of executing the innocent. We sought to determine how the Missouri system operates in design and practice, and to identify the strengths as well as the areas in need of reform or review, and then make our recommendations to improve identified problem areas. In making these recommendations, we focused on developing specific, achievable reforms. Using these protocols as our guide, we began the task almost 2 years ago, early in 2010. During this time, we worked with a number of state agencies and individuals in collecting the data needed to complete the report, including prosecutors and defense attorneys, the Office of State Courts Administrators, law enforcement agencies throughout the state, and others. Exhaustive legal research also comprised a substantial amount of the documented material contained in this report. You'll find in the beginning of each chapter a review of all the statutes, rules, and court decisions that affect the various areas that are addressed in those chapters. Two members of the ABA staff have provided great assistance to our team in terms of research and providing our group with drafts of the assessments from which we conducted our work. And I'd like to introduce them and thank them for their assistance: Sarah Turberville and Mark Pickett. As you can see, there's an executive summary in the front. Some people say, where are the cliff notes? I would direct you to the executive summary. But it's followed by 13 chapters covering different areas that we assessed. The report certainly identifies some areas of strength in which Missouri has made progress in achieving fairness and accuracy in the administration of the death penalty. It also identifies areas in need of reform which must be addressed. It is our hope that the findings will prove to be a great resource for those looking into the administration of the death penalty in Missouri, and that the report will be a guide for changes that must be considered to ensure that our system functions fairly and also minimizes that risk of executing the innocent.
Thank you, Doug. Good afternoon. After our 2-year review, the team developed a series of important recommendations for reforms to Missouri's death penalty system. Our guiding principle was our unanimous view that as long as Missouri imposes the death penalty, it must do so in a manner that guarantees fairness and reduces to the greatest extent possible the risk of executing the innocent. To this end, the Missouri system has, in some areas, made progress in seeking to provide fairness and accuracy in its death penalty. So first, as an area of strength, Missouri has established the Missouri State Public Defender, a statewide public defender system which represents the vast majority of indigent capital defendants and death row inmates at trial, on direct appeal, and during state post-conviction proceedings. The existence of a statewide entity with a professional staff dedicated to the representation of capital defendants and death row inmates helps helps to ensure the fairness of capital proceedings and protection of the rights of the accused. Eyewitness misidentifications in lineups and photo spreads can occur due to officers inadvertently providing feedback to the eyewitness, insufficient number of lineup or photo spread participants, and other deficiencies. In addition, fully recording eyewitness identification procedures and custodial interrogations will help reduce wrongful convictions. Although Missouri requires law enforcement officers to record a custodial interrogation in a murder case when feasible, Missouri does not require that the entire interview be recorded, and law enforcement agencies are entirely exempt from the recording requirement under a variety of circumstances. And because Missouri does not require preservation of evidence for as long as the defendant remains incarcerated, not all defendants will be able to obtain DNA testing of evidence that could prove their innocence. A Missouri death row inmate who wishes to pursue a claim of innocence will be foreclosed from doing so if the relevant evidence is destroyed or missing. And of course, not only do inmates have an interest in the preservation of such evidence, but so does the state, given that the state has an interest in making sure it has the right person. Missouri also does not have adequate protections to ensure that death sentences are not imposed or carried out on defendants with severe mental illnesses and other mental disabilities. While the state has prohibited the execution of people with mental retardation since 2001, defendants with severe mental illness and disabilities that aren't the result of mental retardation may be sentenced to death and executed. Furthermore, because of the inherent complexities and high stakes of capital litigation, it is imperative that every capital defendant be represented by a well-trained capital defense team, consisting of 2 capital qualified attorneys, a mitigation specialist, and an investigator.
Identify the number of areas in which Missouri's death penalty system falls short in an effort to afford every capital defendant a fair and accurate procedures and trial and minimizes the risk of executing the innocent. With that in mind, our report spells out a number of ways in which Missouri's death penalty system can be reformed to correct these problems. As Paul mentioned, many of these recommendations must be addressed and can only be addressed by the Missouri legislature. First, there must be a review of the aggravating circumstances in the death penalty statute to ensure that only the most egregious murders are eligible for the death penalty. Under the current law, virtually any murder is available for the death penalty, which increases the risk of the death penalty being arbitrarily applied. What we have in place has developed over time, like much legislation, in a piecemeal fashion. We need to step back and consider the statute and aggravators as a whole.
Whether that opinion holds any sway now, I may not be as firm in that resolve now that I was then. And I can tell you, there were 3 on the Judiciary Committee who voted against it. It was in 76 or 77. And the 3 who voted against it, it was a mixed bag, as you very well remember. I just think if we're interested in life, this is one, and there are no take backs.
I'm carrying that today. That's my bill now.
And we don't have all the members of the team here. I think I would respond to that. We got to know the team members pretty well and got to know what projects they've worked on in the past and kind of political events. And I'd say we had a pretty diverse group. And I would be able to say that there were members on the team that opposed the death penalty